we would move for involuntary dismissal based on MCR 2.504B2 to close the plaintiff's case. She's asking for a refund of fees that are just not due. There's a signed fee agreement that says if you file bankruptcy within a year, if you don't, you'll get any refund at all. And she didn't file within a year. The agreement also indicates the client has certain responsibilities and duties to do, and the client didn't do them. She didn't pay the full retainer. She admitted that. Mr. Steinberg testified that I mean, there's no testimony that says she paid the full retainer. Both sides testified that the full retainer wasn't paid. Also, although she claimed she didn't receive 2 different lists of documents, Mr. Steinberg testified that 2 different lists of documents were provided to her at different time periods. He also provided testimony confirming that the full amount of documents that they need to file a bankruptcy were not received by Mr. Thompson. He also testified, Judge, on several different occasions that you can't file a bankruptcy without that information. You just can't. You have to verify bank account information, income, lawsuits, real property, vehicles. I mean, all these different things, taxes, all these different things you have to verify before you file a bankruptcy case. He testified that he did not have all that information from her. 2 different lists were provided to her. She didn't get on the full lists. That's aside from the fact she paid the full retainer to file the case. So it was never completed on the client's part to file a bankruptcy case. Ms. Thompson, the theme of her entire lawsuit is, you didn't file the case for me, you didn't file the case for me, you didn't file the case for me. It's not a simple matter of going to the office and saying, hi, I'm Carolyn Thompson, file my case. No, it's a matter of the client doing certain things that are enumerated in the fee agreement that she signed, saying, here are the things you have to do before we can file your case. There's been no testimony that she did those things. In fact, the testimony is that she didn't do those things. So he couldn't file the case for her. So she's not entitled to a refund under the fee agreement. The fees are reasonable, customary, and usual, as the Attorney Grievance Commission clearly investigated and clearly found. In this case, she has no case. We're asking for a dismissal. Thank you.
I'm making a mistake.
Ma'am, you get to respond to his motion to dismiss. He's thinking, the argument is basically that on the face of everything you've presented, basically that there's no basis for you to recover and that I should dismiss the case without, just on its face right now, based upon the evidence that you have presented. That's basically his argument.
Okay.
And the argument is basically that you didn't provide them with all the information they would have needed to file the bankruptcy in the first place. And so therefore, they couldn't have filed it.
So, Your Honor, I want to say that I do have the information they sent to the Attorney Grievance Board shows that they had information enough to file my case, and all the things they said they would have missing. And also in my defense, Your Honor, I subpoenaed Noel and his assistant, who he claimed that I had given documents to as well. But he never let Noel come here and testify.
You couldn't file any type of relief, because if there was a signed subpoena and you asked for the person to come, they can't just ignore it.
And they
Judge,
did,
he was here on that
still
day.
didn't come.
He was here on that day. He was subpoenaed to be here on October 30th. He was here that day, waited all afternoon. He was never called. He's never been subpoenaed to come to 3 subsequent trial dates, including today.
Your Honor.
Ma'am, I don't know if he was here.
He was not here, and we acknowledged that.
No, we did not acknowledge that, Judge. I'm telling you as an officer of the court that Noel Cimino was in this building right outside that door on October 30th. The problem is that the testimony, the first witness,
Yeah, Mr. Steinberger, just went on
4
and on.
trial dates.
Yeah.
So.
But the thing is, Judge,
So you would have had to resubpoena him.
No, they said they didn't think he needed to.
Well, ma'am, you know what? Let me just say this. They don't control this process. The rules do. And if you had subpoenaed him and he didn't come, you could have proceeded to take your remedy under the court rules. I don't know if he came or not, because you never got to calling him. You went on what they told you. I don't know why you would go on what they told you. You should have brought it up and said, hey, I subpoenaed him. He's not here today. And that if he was here, they would have brought him in.
I did.
Or you could have re-subpoenaed him for another date.
Well, after they said they weren't going to subpoena him, I thought.
No, they don't subpoena him. You would subpoena him.
But what I'm saying is, if I subpoenaed him and they were served, they
He would
should
have had
be
to been served.
accountable for not following the law.
Ma'am, he would have had to been served. And if he didn't come, he would be responsible.
I did serve
for-
him,
for-
matter of fact.
Okay,
I did.
but I don't know, it's too late now, because I don't know if he was here or not.
Okay.
But I'm saying that if you went past that day and you wanted him to come on a different day, you could have resubpoenaed him for a different day. Or asked me to continue the subpoena if he was here. I don't know if he was here.
They did not disclose that he was here. They said he was not here because they felt he didn't have to be here.
That is
If they would
absolutely
have said he was in
incorrect,
the
Judge.
hall, I would have said for
Judge,
them to bring him in.
I'm sorry.
Why was it that somebody
I
subpoena said?
cannot
Okay, hold
listen.
on. I can't hear both of you.
Why, excuse me.
Hold on, Mr. Burke, let her finish.
Why would somebody that was subpoenaed to appear in court sit outside the door?
Well, ma'am, let me just tell you this. I've been doing this for almost 22 years. And I can't tell you the number of times people sit outside the hallway and we don't even know they're here. It happens all the time.
But when I mentioned it and you asked them and they told you they didn't think he should be here, you didn't know he was there. You had to only go by their word.
I don't know.
Judge, I'm sorry. I can't listen to somebody accusing me of lying to the court. That's a real problem for me. That's a real problem for me.
That's what transcript.
Go order the transcript. I defy you to prove to the court that I lied to the court and said.
Well,
Mr.
ma'am,
Spino's not
whatever
here.
date it was, you can get a transcript
I
if you want
will.
to do that.
Absolutely get the transcript.
I'm not
But
sure where
Judge,
we're going with
And
it.
if she's not telling the truth today, I'm gonna file a motion for sanctions.
Your Honor, don't you have something in that file where it showed he was served, that he was supposed to be here and was served?
I should have a
Can
return
you
of
check
service.
that? Cause then that'll let you know that,
But I don't know if he was here.
right, but
Even if he
you
was
still know
served.
that he was served.
October 30th, no Semino. Yeah, here it is. I don't
And
know.
they
But I don't
finally told me that they didn't think he needed to be here, and that's on court transcript.
Judge, I'll just read you what I said a moment ago.
Tuesday, 10/26, he was served.
And he was here on October 30th. He sat up in the hallway for 4 hours waiting, doing literally nothing but waiting.
Why didn't he tell me that?
You were right in the middle of an examination of another witness. It took 4 trial days.
Wow. Who comes to court subpoena and sits in the hall and don't even check in with the court clerk?
A lot of people do.
That's
Maybe
just
the
another
question-
tactic that they
maybe-
know I'm not aware of.
May-
And it goes along with all of this pulling it out of small claims
This
court and
is-
everything trying to intimidate.
this is
me.
Ma'am, this is the rules.
Okay.
You cannot accuse somebody for following the rules that's trying to intimidate you. The
This is-
rules say they can do that.
He spoke and said in court that he doubted if I knew what a rebuttal was. That
Ma'am,
was him clearly saying he thought I didn't have intelligence.
yeah, well,
Just so
first
we're
of all-
clear,
First of all, that's a lot different than saying that they're trying to intimidate you. You've done a great job for yourself as far as I can see, number one. Number two, though, they get the chance to use the rules too. And the rules say that they can remove it if they want to have a lawyer. They can remove a small claims case to the general civil docket. Happens all the time.
I know, I get that. You explained that to me very well, but I'm saying from the way he's conducted himself in all of these motions to cancel and drop.
Ma'am, these are part of the proceedings. You cannot say that somebody's trying to do something and getting that, well, that's their job, just to fight the case.
It could have been handled in small claims court. even
Well,
though
ma'am,
they had the option.
but they don't have to do that if
Right,
they want a
so it's
lawyer.
part of the tactic to just wear me down.
But you know what? Let me
go
just say
against
this.
What I don't know.
Let me just say this. Lawsuits do require, quote, tactics. Everybody has a way that they're going to handle their case. You got one, they got one. So they decide that they want to use the rules, which allow them to come to this court with a lawyer. You call that a tactic? That's a tactic, but it's a legitimate one. They get to have a lawyer, which they cannot do in small claims court. You now get to have a lawyer too. You don't have one. Why? I don't know, but you could have chosen to get one if you could find somebody to take the case.
It wasn't worth it for the small amount of money, and the retainer was clearly stating that.
So then that's why you're kind of sort of the way this falls, just the way it happens. You're small claims court removed. Now you're in general civil court where all the rules apply.
Right.
Small claims court, those court rules, most of them, they do not apply. But this is different. So I gotta hold you to the rules that apply. Just like I have to hold him to. He just knows the rules better.
They can actually hide somebody that's subpoenaed outside.
But I don't know if they hit him or not, man.
He said that. He was sitting outside for 4 hours.
Judge, this is Ms. Thompson's case. She subpoenaed Mr. Semino. She could have walked 25 feet and checked in the hallway.
To see if your witness was here.
Exactly.
Not if you told me he wasn't here.
Oh man, okay, let me just say this. Do you listen to everything somebody says?
Judge,
he's supposed to be an attorney with integrity and upstanding.
But it's your position that this is your case, so get up and look and see if the person's here. I don't know if they were here. I don't know if a ruse was pulled over your eyes or not. All I
know he told you on the oath that he didn't think it was.
Okay, but let's just say he said it. Then where are we? What's the relief you're seeking? Because he's told you the witness wasn't here.
The relief I'm seeking is for them to stop saying I did not provide the documents. That's the only thing they thought that carried some weight.
But how can I change their testimony? That's nothing the court can do.
True.
That's their testimony.
Your Honor, I have some papers here somewhere.
Okay, man. Let's move along.
Okay.
He did an oral motion to dismiss. What is your response?
Let
me tell you what the standard is. That there's evidence that was presented that when viewed in the light most favorable to you, the non-moving party, suggests that there is enough evidence for a trier of fact to weigh it and come to a conclusion that you might be able to recover. He's saying there's no way. That the contract said this, the evidence said that, and therefore they're entitled to dismissal. What is your response?
I'm just at the mercy of the court at this point. I was looking for protection, legal protection under the law.
Okay, but you don't have any argument to the motion then?
To dismiss?
Yes.
Yes, I think it's no grounds for dismissal because they have provided misinformation and they failed to have the attorney come into the courtroom during a subpoena, and all the statements that they made are untrue, and that they cannot use a retainer for their own personal fees when the law said, Michigan law says a retainer is specifically for work performed for a bankruptcy, and it is to be held. It does not belong to the attorney until a case has been established and the case has been completed. There was never a case established. There were no filings, no meetings, no anything.
Okay, right. The question is there enough evidence here to get to the trier of fact about this matter? And the whole argument is about this Chapter 7 fee agreement, which when you look at it, it says attorney fee is $800, credit report $20, $820 total fee plus court cost $335 for $1,155. And it says that the fee must be paid in full prior to filing a petition unless otherwise agreed upon and signed by a supplemental addendum. And then there's a refund policy says, well, they don't refund fees if it's less than $500 plus the costs incurred. And there's some other parts of the fee agreement that say if the file remains unfiled for 12 months and the client has failed to complete the filing process, there'll be no refund of any part of any funds that have been paid to the attorney. And then there's another part that says something about that the client has a responsibility to obtain documents requested for preparation of case, including creditors, addresses, deeds, mortgages, titles, tax refunds, divorce judgments, sales agreements, asset valuations, wage records, and other information requested by the attorney. This is a lot of days of testimony, so I really haven't had a chance to look at every single thing that was said by every witness. But the argument is that Mr. Steinberger has testified that that he never received the full cost that he was expected to receive, and that there were documents that he asked through his attorney representative that he asked the plaintiff to provide that he never got, so he didn't have enough information to file the bankruptcy in the first place. And then there's the question that is not so clear as to what's happening here. Let's see. Plaintiff says she got $220 back. She says she paid the full $820. She didn't pay the whole balance. She claims she did provide documents that were requested. And she never did get this list that the plaintiff said that they generally provide, because she brought everything, was told on the phone what she needed. And that she's looking for her $600, which she says she's entitled to under this agreement, under the fact that it's been, in her view, less than 12 months since she failed to complete the filing process. And it was less than that, not more. Then there's the argument that, okay, there was $100 that was down paid when the client and the attorney first met in 2019, and that she never did pursue it back then, but then called back later, I guess it was 2020, I believe it was, and asked to start the process again, and then she did pay money. And she says she never paid the she paid $150. He agreed to accept the $100 from before and to proceed to file the bankruptcy, even though allegedly, I think the defense is that, well, this is the same case. She says the first case was closed. They say, no, it's not, because there was no new retainer. But then they started the new process, or whatever, continued process from the plaintiff's, from the defense perspective, new process from the plaintiff's perspective, using the same money from the $100 and well outside the 1-year process from the first signing of the retainer, which was the same problem that trier fact. The question is, what would a trier fact do here with respect to the timing of the whole thing? I think some of the things may or may not be clear as to how much money was paid. I mean, that should be easily seen, that I don't think the full amount was probably paid pursuant to what was requested. But the dates, when did this, was this the same agreement? Did it start over or not? I guess is the question. And if it didn't start over, then why weren't new fees then processed pursuant to the schedule that's apparently they would have listed here as starting all over again with another down payment, etc. So it creates a question where a trier fact could potentially come to a conclusion that perhaps this might have been a quote new agreement, and that in fact she did request her money back within the time frame, which is why the summary disposition motion was denied in the first place. It's the same issue. So for those reasons, the motion to dismiss is going to be denied. Okay. Do you have a case that you want to put on in addition to anything he said previously? Do you have any other witnesses other than Mr. Steinberger you wish to come that you listed? No.
1 moment, Judge. Judge, we're going to call Mr. Steinberger again.
Okay. He'll be witness as witness kind of sort of number 3 now in his case. Come on up, Mr. Steinberger. We'll give you an oath again. All right, raise your right hand. You solemnly swear affirm that the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Okay.
Judge, thank you. Mr. Steinberger, we've been here several times. We've talked about the fee agreement several times. So I'm going to talk a little bit more about the fee agreement just to make sure we're clear about a couple things. First of all, the fee agreement we're talking about is Defense Exhibit A. It's a 2-page document. I was referenced it as June 10th, 2019. Is that your understanding?
Yes.
Okay. And your office signed it and Ms. Thompson signed it, is that right?
Yes.
Okay. The part where it talks about refund policy. Can you just read for the court the very, very last line of the first page that goes into the second page where it says if more than 500?
In consideration of the attorney's initial consultation, opening a file and file retention, there is no refund of any fee paid that is less than 500 plus costs incurred. If more than 500 costs have been paid and refunds are requested the attorney will provide a statement for services rendered and refund the unearned portion of the retainer to the client. If the file remains unfiled for 12 months and client has failed to complete the filing process, there will be no refund of any part of any funds that have been paid to the attorney.
Let me just focus your attention on two words. The top line of the second page, the two words are unearned portion, okay? So the net amount that your office retains from all the payments received and the refund given was what? $600? That includes fees and costs, right?
Yes,
Okay. How much of the 600 is fees and how much are costs?
there was a $20 credit report.
Okay, so,
So 580 would be fees
okay,
and 20 would be for the credit report.
okay. And at some point in time, your office generated an invoice, correct?
Yes,
And the invoice identifies the work that was provided. Is that correct?
yes,
Okay. The invoice is actually marked and admitted in evidence as exhibit, I think plaintiff's exhibit 1, if I'm not mistaken. It's the invoice dated October 4, 2023, is that right? Do you remember?
I have a copy of the invoice.
Okay. Judge, does the court have a copy
What are we asking?
of the invoice? It's plaintiff's
This is the
exhibit.
one that you made during the trial.
Right.
Correct, yeah,
Yeah,
okay,
that's right.
yes. So, Mr. Schneider, you're looking at plaintiff's exhibit 1, is that right?
Correct.
Okay. And you prepared this invoice, your office prepared this invoice, it's showing a description of the work that was provided on behalf of Ms. Thompson, is that right? In
Yes,
fact, it has Ms. Thompson's name on the invoice on the left side, towards
yes,
the top, and even farther below in big print, it says Thompson Bankruptcy, is that right?
yes,
Okay. And it has 2 pages of detailed work that was provided, is that correct?
correct.
About a page and a half. Okay. And this invoice was not sent to Ms. Thompson, correct? As far as wanting payment, is that right?
Right.
So you never said to Ms. Thompson, here's an invoice, we expect payment now, is that right?
No,
Oh, let me ask a question on that.
Sure.
But was it ever sent to her where it says the attorney will provide a statement for services rendered and then refund a portion of retainer to client? Was it provided to her for that?
No.
no,
I'm asking him, not you. Okay, so we just first saw this when it was introduced in the evidence. Is that really what I'm hearing? It says it was created on the document 10-4 of 23, so that's about right?
right.
Okay, all right.
And so if you look at the bottom line, the total amount of time that was spent, calculated based on various hourly rates, the total balance due would have been what?
613.
Okay. And the fees, does that include any costs at all or no? Just time?
No,
Just time.
time.
And the total fees retained by your office was $580, I think you testified to?
Correct,
So there is no unearned portion. Is that correct?
correct.
Okay.
So why did you refund anything?
We refund money basically, generally, because we just think it's reasonable or fair. And we refund money sometimes just to foreclose any issues with the client. Sometimes clients get refunds and then they come back to us. So it's just a matter of policy. We don't necessarily keep everything. Also, we believe that it was pursuant to the fee agreement, no matter which way you interpreted it. Because one interpretation is if more than a year has passed, there's no refund. And so, okay, if that wasn't true, since she reopened her case and we started the case again, she had only really paid $720. And so we thought, well, if you look at it in a different way, there's no refund pursuant to the agreement, less than 500. So we met that obligation too. So we refunded it that way. So depending on how you looked at the retainer agreement, which way you look, whether it was 2019 or her date of 2020, and it was within the year, and either way, we felt that we had fulfilled our obligations under the agreement.
So the 720, if you talk about the 720 from the 2020 timeframe forward,
Yeah,
the 720 that was paid, you refunded 220.
exactly.
So there's 500 left over, but again, only 480 was
Well, if you take into account the credit report for $20. Right.
Okay, so
Yeah,
that's
that's the
under
same
$500 in fees.
Yes,
So if you look at it from her perspective, where it restarted in 2020, there was only 480 earned or 480 retained as far as fees.
I object.
Ma'am, that's a question.
correct,
You can't, what's wrong with the question?
correct.
I paid more than that. The $100 carried over from 2000.
So she wants it both ways, Judge. She wants the 2019 contract to be
carry the
back.
$100
Pardon me,
over to start
pardon me.
over, and he said that under oath.
I understand, ma'am, but he's trying to look at it in two different
Okay, I
ways
apologize. I'm
under
sorry.
this agreement.
Sorry.
He's trying to, this is their theory. So I don't know how you can object to their theory. Their theory is, okay, well, let's just say she did start over.
My apologies.
And that's what his question was based upon.
Judge, her claim is that the 2019 contract was canceled. But yet she wants to use the $100 payment in 2019 to carry over to the 2020 contract. So she wants her cake and she wants to eat it too. I mean, she wants it both ways. I mean, it's either the 2019 contract controls or it restarted in 2020. But either way, based on the testimony that you just heard, either way, there's no entitlement to refund at all. So whether it's the 2019 agreement and there's 820 minus 220 and there's 600 left over, there's 580 being fees, there's still 613 that was earned, right? If you look at the 2020, okay, fine, 2020, there's 720 that was paid, the 120 and the 600, 220 was refunded, that leaves 500 if my math is correct. Take off the $20 for the credit report fee, that means 480. And that the agreement says, if I'm not mistaken, there is no refund of any fee paid that is less than $500, period. So in that case, the 480 is not refundable. Either way, it's not going to be refundable. So anyway, Mr. Steinberger, let me ask you. Let me shift gears for a second. How many times did your office provide Ms. Thompson with a list of documents and information to provide in order for your office to prepare her bankruptcy case for filing? Twice. Okay. Once was in the June 2019 consult.
Correct.
Okay, and then once was in December 2020 when she decided she wanted to try
Right,
to
he
start
had
her
to-
bankruptcy
You
process.
had to update it. I don't know the exact date, but you're correct. It was provided subsequently when she wanted to update it because you have to have current relevant documents.
Right,
to
and you explained this thoroughly at I think the last trial date, I believe, about the means test and about qualifying for bankruptcy, right?
Correct.
Okay, and just, I don't want to spend a whole other day.
No, you don't have to.
Right,
I
okay. So the point is that when a client comes to your office and says, I want to file bankruptcy, there's documents and information that are required that they have to provide, is that correct?
Yes,
Tax returns, bank statements, case stubs, real estate information, vehicle titles, that's some of those things roughly?
yes,
Okay, and your office also has to do searches online to find out if there's any lawsuits or judgments, is that right?
correct.
And why do you do that?
It's required to an attorney provide due diligence to file a case with the court. In other words, you have an obligation to check the information the client provides to make sure it's accurate for the bankruptcy petition. Should not be submitting a petition where you've not some basic investigation of the bankruptcy case.
And that information, if it's out there, lawsuits and judgments and other creditors, that stuff gets all put into your bankruptcy petition schedules, right?
Yeah.
Okay. And was there ever a time from June 2019 until today's date that Ms. Thompson's file was ready to prepare for bankruptcy filing?
No,
Okay, why not?
reason. She did not provide all the documents and did not make all of the payments.
Judge, thank you. I have no further questions.
Ma'am, do you have any questions of the witness?
Do I have any questions?
Yes, based upon what he just testified to.
Absolutely. The, are you stating, first of all, do you have anything in writing that you sent me something? Because you never
Sent you something of what?
about documents, missing documents, because you did a whole workup with the information I provided?
Okay, ma'am, it's gotta be a question. You're
Oh.
basically telling him something. What is the question though?
Did you not make up a whole statement? Or did you not prepare a whole, worksheet and documents ready for bankruptcy in my case?
I'm not sure exactly what.
I don't know what are you referring to? A worksheet?
Well, let me ask you this. What do you claim to be missing? That might be a better question.
You needed your, at that time, 2018 and 19 tax return, proof of your pension information, title to your vehicle, 4 months, most recent 4 months of your bank statements, your life insurance policy from Colonial, your statements from the IRS, copies of the lawsuits from Avenue and Carriage Park, social security card and ID license.
And you're saying that's what you did not receive?
Correct.
You got all of that?
Judge,
And
that's
that was-
argumentative.
Oh, no.
You're not testifying.
Okay, right.
He
So you're
said what they
saying
didn't get.
He did not
That's what he told you.
receive.
And I missed some of it, but I can think I got most of it. I got 2018-19 tax returns. I know I missed something. A vehicle title, pension information, life insurance policy, IRS statement, social security card, ID license, and there was a couple other things.
Your Honor, if you'd like, we can mark that as an exhibit and have it in evidence. I don't know if I have an extra copy or
His
not.
testimony's fine. What did I miss?
If his testimony.
Statements from the IRS
I got
and
that.
state of Michigan for amounts years owed, copies of lawsuit documents.
Lawsuit documents.
Avenue was one of them. It's a store, I believe. Carriage Park's apartment, various other lawsuits mentioned. And then just ID information. Social security card and ID.
Did you?
And
say-
Judge, if
Excuse
you.
me, I'm still.
I'm addressing the court though. Judge, if you don't need a copy of that, we don't have to, if you don't want to admit it, that's fine, as long as you're okay with the testimony.
It's his testimony of what he says that he's missing.
Okay, but we have a document to back that up. I just didn't know if the court wanted a copy of that
Well,
admitted.
I can't tell you what you, it's
Well-
not what I want, it's whatever you want to do.
Well, no, okay, so,
I'm good with the testimony, and she's saying
okay,
she hasn't rebutted it yet.
if you're good with the testimony, that's fine then. Thank you, Judge.
Do you have any documentation that you sent me any information to that effect?
I have a copy of this information sheet, which is provided to you for preparation of the case.
That's not my question. My question is,
It was
do
given to
you
you
have
at the,
any, no, excuse me, sir. My question is, can you provide any documentation that you reached out to me in writing, asking me for anything? Or stating that that was what was holding up my case? Because you said yourself under oath, did you not say under oath that it was the money that stopped you from proceeding? And did we not clarify that at the trial before this, that regardless to if you had a piece of blank paper, that did not stop the bankruptcy? It was the money.
there were
The-
two
the
reasons.
fee.
It's two reasons.
But the fee of.
Ma'am, you
Okay,
gotta let him answer.
okay, I'm sorry.
Two reasons. The fee and the documents.
So, again, the fee took precedence over any paperwork. The fee. And if that's not so, why did you not send me something within that 9 months saying, I need such and such? Why didn't you disclose that to me?
Judge, that mischaracterizes his testimony. He's testified on numerous occasions. It's both the fee and the documents. I don't think he ever testified that one takes priority over the other. It's both.
It is what it is in the record, and I don't think he said one over the other.
Thank you, Judge.
But the question is still good if she wants to ask him as to, did he send her any information saying that something was missing? And why not is not.
Absolutely.
My paralegal indicated when, in my notes, that she had reached out with you with the list of documents that was necessary to file. She was having conversations with you as to what was needed to be filed.
No, sir, and that's hearsay, isn't it?
It's just what our records show.
I've never spoke to her about any documents needed because as I said, don't you recall me saying that you told me everything I needed to bring and I brought it?
No,
You said that under oath.
no.
Do you recall not understanding what kind of policy I had?
So,
Do you recall us discussing the type of insurance policy I have brought to you?
No,
I can't dispute that, but I had that documentation with me and you don't recall not understanding the type of policy that was.
He said, no, you can't get him to change it.
Okay, well, the information, all that information.
Ma'am, this is just you asking him
Okay.
questions. This is not a time for argument.
Okay.
Yeah, anything else you need to ask him based upon what he just testified to? No?
No, because as you said before, I can't make him
Right,
say it if he doesn't want to say, so.
okay.
Guess
Then if there's no more questions for him, he can step down. Do you have another witness?
I have no redirect, Judge.
No.
Correct.
Any other witness?
Just one moment. Judge, we have no other witnesses. Thank you. You're right.
Okay. Do you have any rebuttal witnesses to rebut anything?
No.
Okay. So now, trying to see if I've got enough time even. I don't think I do to get into the closings.
Judge, our closing can take less than 5 minutes.
That's you. How long is it gonna take you to make your closing argument?
I think I tried to write up something that I consider close. Let me see if I can-
Judge, we have no other witnesses. Thank you. You're right.
Okay. Do you have any rebuttal witnesses to rebut anything?
No.
Okay. So now, trying to see if I've got enough time even. I don't think I do to get into the closings.
Judge, our closing can take less than 5 minutes.
That's you. How long is it gonna take you to make your closing argument?
I think I tried to write up something that I consider close. Let me see if I can-
Thursday, February the 8th,
February 8th.
10:30,
What time? 10?
10:30.
10:30.
Judge, is there any way we can finish today? Like I said, my closing will take less than 5 minutes.
She's not ready. And I have to. Something.
All due respect, there's 2 witnesses in the case. How, I mean, she knows her case. How is she not ready for closing?
Okay. You want me to railroad her?
No, but Judge, this is our 7th trial date.
I don't think, you don't think I know this?
I know.
You know, part of what justice requires is for everybody to feel that they've got a fair shot. And I'm very well known for doing that.
Totally agree.
So I even get litigants that say, I lost. But I felt like you listened, and I had a fair opportunity to present my argument against. I try to do that.
No, Judge, you do a great job. With that. I
If
appreciate that.
she's not ready, I mean, I could do it like right now, but I have to leave in about 10 minutes. And she's looking for her notes at this point. You may be fine.
Should be fine, too.
Basically, I guess what I've been saying. all along.
Okay, well, are you ready to prepare it and give it now or not? Yeah, I got like 10 minutes.
Okay, okay. Do I go first or they?
Yeah, ma'am, it's your burden of proof.
Okay, my
So you go
closing
first.
argument. Mr. Steinberger knows that the only way he has a chance to win this case is to try and tie the closed case into the new case. He should not be allowed to breach a contract, even if it's his own. his own admission that I had lost my $100 when I reached back out to him is an admission that the first consultation case had expired. And he allowed me to carry that $100 over that he admitted under oath. And his attempt to legally manipulate this case, pulling it out of small claims court, which I know he had the right to, but ignoring a subpoena based on false pretense, repeatedly ignoring subpoenas, and not providing what his own retainer had requested, that when a refund is requested over $500, which I had paid $820 at that point, he repeatedly, for the last almost 2 years, refused to provide that document. And then he comes up with some document he prepared, finally decides to prepare after I kept telling him to provide me with that information that his retainer said that he had to provide to show he earned that fee, which he didn't even earn that retainer fee, because according to the state law, a retainer fee is money saved and not to be touched by the attorney until he actually provides the bankruptcy services. The meetings, the case files a case and actually carries out that bankruptcy and the case is closed. He did not do that. I also would like the court to consider the fact that I cannot have him admit, but I brought every document into that office when I came for my consultation. That's why he has no emails or anything to say that he reached out to me and asked me to provide that. He just literally took that money and sat on it. And the only contact after the consultation, which by the way, that draft is erroneous. The consultation was only $100, and a lot of the things that he put in that draft was actually, I was told, was part of the special he was running. But like I said, when I kept persisting that he provide that document, it took him 2 years to draft something up at the last minute for the court to consider. That was erroneous. I also want the court to consider how they misrepresented the monies that was paid to me, even though they had my bank statements and they knew that I had not paid them any money prior to December 2020, except for that $100, but they misled the Attorney Grievance Board by stating they had refunded me $580, which was part of that was $338 that they weren't supposed to take out my off my debit card without my permission. I also want the court to consider the reason why he never sent me any documentation. He didn't even know my address. When I asked for the refund, he had to ask me for my address. And I had a statement to that effect too, where he's saying he didn't know my address. He did absolutely nothing but held on to that retainer that's legally not his, because he did not, the retainer is not his personal bank account. The Michigan state law says that is to be held for future work to be performed that he never did. So at this point, I guess my closing statement is, it's obvious. He admitted right here that, like I said, that I had that first case had closed because he allowed me to carry over that $100 to start a new case. And the fact that no monies were paid to him until December 2020. And as far as the documents go, if I would have given him all the documents, he states that he would not, and he said under oath, he was not moving forward until all the money was paid. Otherwise, he could have started the case. There was no communication with me whatsoever. And he has nothing to prove that he communicated with me. And I also believe that he gave me the $220 back because he knew he should have been giving me more than that. It was just like the hush and go away. So that was, giving me the $220 was not from the kindness of his heart. It was, hoping that I would go away and not pursue the rest of the money that I was entitled. All right.
Thank you, I'll be very brief. Things. First of all, this court is aware the cardinal rule in interpretation of contracts is to ascertain and enforce the party's intent. Macintosh versus Groomers, 227, Mich. 215, 1924, Michigan Supreme Court case, as well as Wilkie versus Auto Owners, which is 469, Mich. 41, 2003, Supreme Court case. Courts are to enforce the agreement as written. We all know the contract law, Judge, but just for purpose of the record. When reviewing a contract, breach of contract claim, the court looks at the plain language of the agreement to determine the parties' intent. Harbor Park Market versus Granada, Gronda, 277 Michigan, 126, 2007. The goal of contract interpretation is to enforce the intent. When interpreting contract, courts are to give the words their plain and ordinary meaning. That's North Line Excavating, which is short site judges, 302 Mishap 627. There's really a couple things here, Judge. The court, I think, recognized during my argument for the involuntary dismissal under 2504, the court recognized that perhaps the full payment wasn't made. That's what the testimony is. So the full retainer payment was never made. I don't think there's a dispute about that. We heard testimony from both sides about the payments that were made, the 100, the 120, and then the 600. So there's a total of 820 paid. There's a 220 refund. That leaves a $600 balance. So if you look at the contract, Judge, from 2019, first of all, let's back up for a minute. This is a 2019 contract from June 2019. It's undisputed Ms. Thompson never filed bankruptcy ever in the last 4.5 years. So she's never filed bankruptcy. So technically there's no refund of any fees in that scenario. If you look at the 2019 date, the contract says that any unearned portion will be refunded. If it's more than, I think, $500. But the unearned portion, or the earned portion was $613, as Mr. Steinberg testified. There was no rebuttal testimony or nothing to refute that. He testified that the earned portion was $613. There was $580 refunded. Again, $20 of that $600 was a credit report cost. So the fees were $580. The fees were all earned. In fact, technically, she may even owe a balance of whatever that is, $33 or whatever it is, whatever the calculation is. If you look at the other interpretation, okay, it started over in 2020. So there was only $720 paid, $220 refunded. Again, the $20, which is undisputed, is a credit report fee, so that the fee, a credit report cost. So the fees would be $480. The fee agreement says that there's no refund of any fees less than $500 under any circumstances. So either way, she got back, she probably got back more than she was entitled to, but she at least got back consistent with the contract under either scenario. So the testimony is clear, Judge. She never filed bankruptcy. She signed the contract. The contract could be interpreted from 2019 says one thing. If you interpret it from 2020, you can look at it a different way. But either way, the Steinberger office is not liable to the plaintiff. She's not proven that Steinberger breached the contract. She's not proven that she's entitled to a refund under any theory. The Attorney Agreements Commission looked at this. They reviewed everything. They investigated everything, and they determined that there was no refund due. He didn't overcharge her, and that she's not entitled to anything, and they're not looking into anything further. Judge, we would ask for no cause of action, dismissal with prejudice, and that's what we're asking. As far as, well, I'll wait for the court's decision on that. But as far as like fees or the request for fees or anything like that, but or not fees, but costs, I guess.
Okay. So the court is going to do a written opinion in this matter so that it is clear as to why I'm coming up with the decision that I'm coming up with. So I'll try to get that out within 30 days, so no one has to come back.
That would be great, Judge. Thank you. Thank you for allowing us to close today, Judge. We
Ron,
appreciate
can I
that.
make one more statement?
No, we're done. Okay. Okay,
Thank you for your time.
well, thank you, and we'll get this out to
It's
you.
been a learning experience, whatever the decision, and I didn't expect I would ever be in a situation like this. where I would be forced to pay so much money for absolutely nothing.
All right.